Make them answer. They ignore you until the record forces an answer. Keep watching, and I'll tell you how I wrote my motion to push the judges to act. So here are some comments I hear regularly. The court is ignoring me, and sometimes they are. The court will never grant your motion. Yep, maybe they won't. And motions sit. No rulings, no explanation, just silence. That's where most people either quit or start filing random things out of frustration and break procedure. Both of those are mistakes. Stop filing emotionally. Start building strategically. Every motion, every notice, every objection should be clearly written for the next court's review. And when the court rules against you, make sure that decision is clearly documented. Because sometimes the judge in front of you isn't the real audience. The appellate court is, the reviewing judge is, and the future record is. So when enforcement is continuing, wage garnishment, license suspension, financial damage, and you file a motion of stay, if they ignore it, file a notice of continued harm, not to complain, but to document and preserve and to show ongoing injury while the court continues their delay, because silence matters. The denied motion tells a story, but an ignored motion tells a story too, and both belong on the record. You're not just asking for relief, you're building proof. That's how you push a case forward. Not noise, not panic, but precision, because the goal isn't just today's ruling. It's making sure the next court can clearly see what happened. In the motion I just filed, I didn't argue, I didn't complain, I stated the facts first. The court gave the defendants a 60-day extension. The defendants still have not produced any evidence of personal jurisdiction. And constitutional harm continues through delay and continued enforcement. Then came my ask. To be fair and to avoid implicating the court in ongoing constitutional harm, either pause enforcement or require the defendants to produce certified documents that supposedly allowed personal jurisdiction to attach. That creates the pressure. If they ignore it, that goes on the record against them. If they deny it, that goes on the record against them. If they order the defendants to answer, their case starts to fall apart. That's the defendant's case. If they grant it, then the harm stops. That's my strategy. Don't give up. Build the record. Force the issue. Make them answer. I'm just going to read you the last section here. Given the ongoing and continuing nature of the harm, appellant respectfully requests expedited consideration of this motion. If the court determines that a response is necessary, appellant respectfully requests that any response be ordered on a shortened schedule. Absent interim relief, appellant may be required to seek further emergency relief to prevent continued irreparable harm. The next step, if they ignore it, is the Supreme Court. I didn't threaten with the Supreme Court, but based on that paragraph, they know exactly what I'm going to do next. Now, do you think they really want the Supreme Court to keep seeing them ignoring my motions or ignoring this personal jurisdiction issue? I don't think so. That's what pushes the court.